I have no witnesses. I don't know if Mr. Summers wanted to address the court.
He certainly may if he wishes to.
I can agree.
All right, let me swear you in. If you raise your right hand, thank you. You swear to testimony you give the truth, the whole truth, and nothing but the truth, so help you God. All right, you may proceed.
Your Honor, I would like to say that one thing that's tough about all of this is not being able to communicate while this is all happening. And for that, I certainly regret the inability to let Art know that she's never been to blame since the beginning. That my children are wonderful, that they are strong, that they had a good foundation, and they will continue to have a good foundation. And also to be able to simply say sorry to Elisa, her family, for the pain that they've experienced. My biggest remorse and regret is that they feel the way they do about me. I do have memories, and I know they can find some in there somewhere. And I pray that they would know that they were loved. That sometimes things just don't turn out the way that we intend them to turn out. And that again, if I would have been able to, right when this had happened, I would have apologized then. I would have been able to express, I would have been able to express my concerns and I appreciate the opportunity to get to speak, but I can't say too much about the case as a concern and caution for potential appellate issues. But I can say from my heart that I certainly would have made this right sooner if I would have had that door open to do that. And I understand the position I'm in while being a defendant and not be able to communicate that apology soon. I do ask you, Your Honor, to just consider facts in the case and my heartfelt sorrow for the way that they feel. And Your Honor, I will continue to pray for you and help you be strong through this. Thank you.
Hold on. Mr. Marchese, did you have any questions of Mr. Summers?
No.
Did it say that?
No, Your Honor.
All right, thank you. Anything else from the defense before I hear? My intention is to, well, first let me ask, because I think you have in your hand the pre-sentence investigation. Is that correct?
Yes, sir.
I just want to make sure that everyone received the pre-sentence investigation, which we actually received this morning, and I've had the opportunity to review, and a copy was given to each side. So, Mr. Marchese, you do have that?
I haven't. I've discussed it with Mr. Summers. He has a copy.
Excellent.
Yeah.
There's one thing that I want to, there's two number ones, and I want to make very clear that the first number one is not a charge that was tried as part of this case. It is a separate case number that is still pending in front of Judge Busan. State, am I correct?
That's correct, Your Honor.
Okay. So I just wanted to make very clear that there's no misunderstanding regarding the PSI and the inclusion of that case, that charge on here. It is reflected at the top by the different case number 3962. The rest are 3817 CF 3896, which includes the 11 charges that were tried by the jury in this case. Do you agree, Mr. Marchese?
I agree, but that number one on armed false imprisonment, it listed it as being adjudicated, which it's not.
You are correct, and I will note that because you are absolutely right. It is pending.
Pending.
All right. So it's an error on the PSI, whether it's a typographical error or whatever. The court is aware of it and will certainly take that into consideration as to any weight that I give to the PSI. Ms. Johnson, did you want to be heard on that at all?
No, Judge, and I did not include that charge
the-
on this score sheet.
Score sheet, okay, and I appreciate that. All right, so Mr. Marchese, I'm going to turn to the state now and ask what sentence they are requesting, and then I'll give you an opportunity. You have something before
I just want to make one complaint about the score sheet.
Hold on, let me find it. I have it somewhere. Here it is. Yes.
We have, Your Honor, as to prior record, of course, he has no prior record, he's pending the sentencing in federal court, he has no prior record. They listed a number of 8 misdemeanors, but all of them are 10 years old, if not more. And so we object, it's only 1.6, maybe a month, but, you know. And we're objecting that all of those 8 misdemeanors are all remote in time, they're past 10 years. I think the ones that we have, this last one was 1994.
But is there any, do you have any authority to support the, I understand as to credibility of a witness, that there may be a 10-year limitation, but as to the score sheet, do you have any authority for a 10-year on prior crimes being included on the score sheet?
Sure, it's the other way around. To impeach a witness, you can impeach a witness with a crime any time you committed a crime 15, 20 years ago, it would be listed. But as a score sheet, my understanding, they can only list crimes that are not remote, that are a minimum of at least 10 years or younger.
Okay, I'm going to say to respond. I hear argument all the time, the 10 years, and they steal that from the federal rule with the 10-year limitation. But I hear in this courtroom all the time that I shouldn't consider or allow impeachment of crimes beyond 10 years, and I think there's some authority to support that. Let me ask the state, do you agree that these on section 4 prior record are more than 10 years old?
Judge, I know we discussed, Mr. Marchese and I discussed this during the pendency of the case, or I discussed it with Mr. Summers. I honestly cannot remember. In the abundance of caution for this not to be an issue, I will remove these 8 misdemeanors.
I think they should be. The statute says if they were committed more than 10 years before the alleged crime in this offense, that they should not be included.
And I honestly cannot tell you, Judge, because I know that even though he hasn't been sentenced on the federal charges, if he committed those within the 10 years, then they would be able to come on. But since it's only 1.6 points in the abundance of caution, let's just remove it.
All right, I agree.
And I found that information from the pre-sentence report. It gives us all list of convictions. The last one was 1994. So yes, 1.6 months, but I'm with that.
All right, no, I understand. And the state is conceded, and I'll ask an amended criminal punishment code score sheet be submitted, but for purposes of the sentencing today, I will subtract those points.
Yes, Judge, so it's going to
1.6.
be, bottom will be 385.35
That's months.
months.
All right, perfect, thank you. All right, so anything else, Mr. Marquez, before I turn to the state to see what sentence they're seeking?
Thank you.
All right, Ms. Johnson.
Judge, the defendant faces life on counts 1, 2, and 3. On the sexual battery counts, Judge, those are second-degree felonies, which is a maximum of 15 years. On the child neglects, those are a maximum of 5 years. And on the last count, Judge, grand theft motor vehicle is also 5 years. And on the last count is a misdemeanor, so it's a first-degree misdemeanor punishable by 364 days. Based upon the victim's wishes, the severity of these crimes and the number of crimes and the manner in which the defendant committed them and his multiple confessions to them, we would be asking the defendant be sentenced to life as to counts 1, 2, and 3, and the maximum penalties as to all other counts.
Let me just ask you, do the maximums as to counts 4 through 10 increase to the amount of the bottom of the guidelines?
I'm sorry, I don't understand your question.
Is the maximum, or actually the required sentence of each of those, not the 385.35 months, instead of 15 years as to count 4, 15 years as to count 5, 5 years as to count 6 through 10? You asked that I sentence it to the max, but I thought I heard you say 15, 15, 5, 5, 5. So what is the appropriate sentence when he scores higher than the max?
The court can make finding as to sentence him more based upon the bottom of the guidelines.
I'm not required to do that. Lowest permissible sentence must be imposed when the score exceeds the statutory maximum. You want to take a moment?
Yes, Judge.
All right. Just for the attorneys, I'm looking at section 921.0024, subsection 2. And the specific language is towards the end of that paragraph 2, where it says, if the lowest permissible sentence under the code exceeds the statutory maximum sentence as provided in section 775.082, the sentence required by the code must be imposed. Are we not in that situation?
Judge, can you approach for a moment?
Yes, absolutely. All right, so now we'll turn to the defense. If any of you come back to that, Ms. Johnson, we will. Essentially, though, is the intent of the state to ask for the maximum sentence as to each and every of the 11 charges. Is that correct?
That is correct.
Now, as to the misdemeanor, would you agree count 11, that should actually be time served at this point?
Yes, Your Honor.
All right, Mr. Marchese, I'll turn to the defense now.
Your Honor,
And I will be looking for how much credit he has. He's been in the county jail for some period of time, so
I'll have to count that up right now. I need some time to do that.
let's do this. That'll come at the end. I will give him credit for every day he's entitled to.
Your Honor, I would say, I still have all my arguments about the case and the jury instructions and all that. Getting past all that, we have a conviction for all of these charges. They do score out to a substantial amount of time. I would argue, especially now when we eliminate the misdemeanors as a prior record, you're looking at a man without any prior convictions. In the sense that as we're sentencing him here, you're sentencing him for the first time on anything that could be considered. He has not lived a life of crime. He is not a violent person. There have not been any violent crimes that he has been convicted of. It's not that he's a pattern of violence. I would argue the extent that there are mitigating factors in that this has been an isolated incident. This was a man who had a long, long marriage. They were sweethearts. They had 5 children. And for that relationship to break up and divorce obviously didn't sit very well with him. That doesn't mean that he is a criminal by nature. Nothing indicates that that's what he does. So we've heard from his ex-mother-in-law about statements that he made or the kind of life that he lived. But as far as criminal crimes, he has none, nor the convictions. So we would argue this was an isolated incident that had to do with his wife trying to reach her to talk to her as she's moving on, divorcing and moving on with someone else. We would also argue that this was very unsophisticated, certainly wasn't planned, a very unsophisticated manner that went on minute to minute to minute that ended up dead. For that, you could also know that Mr. Summers has been respectful to the court at all times. He's never been disruptive. He has his own theory of a defense, what to do with that, but that's what he wanted to do to present the case that he wanted to present. I agree with the court that the cross-examination of the children was very disturbing for everyone, including the children. I'm sure Mr. Summers was in that position where once he took over representation of his own case, he had to take it all the way to the end, which included cross-examining his children, which I'm sure is very difficult to do. Although the situation, everyone on the victim's side is screaming for life in prison, I do not see that as the proper punishment here. Again, look at his prior record. Does it look like he has any? This was an unsophisticated event. It certainly wasn't done for any pecuniary gain. The idea that the whole thing was about stealing a car is just ludicrous. But that's what they charged him. It was obviously more about the relationship breaking up. He wanted to try to convince his wife to stay together, and then whatever happens. But there are a number of crimes that he's been convicted of, and he's going to be sentenced to a number of years. I ask that you consider the bottom of the guidelines, the lowest permissible amount, which is about 32 years in prison.
I have 32.1125.
Yeah, that's about exactly what I have about it, at the low end of the guidelines. And I ask that there's also argument to be departure downwards because it was unsophisticated. And he didn't express remorse today. So that would be a good ground for him. Now, if we look at him, he is 45 years old as he sits here. A 32-year sentence would be a life sentence. Possibly could be a life sentence. He'd be well into his mid-70s if he'd be able to get out. If he gets out. Any time more than that would definitely be a life sentence. And I would say that children would not have to worry about Mr. Summers ever getting out. The child neglect charges are neglect charges for sending them away, putting them in the car, and having them go. They're not abuse charges as we would see in juvenile cases. This is a neglect situation that obviously showed that he loved his children and wanted his family. I think all of this was about trying to keep his family together and having it all go away. In my opinion, everything just got out of hand. It wasn't planned or pre-planned. For that, he has to be punished for what he's done, for the crimes he's been convicted of. And we ask for you to abide with the guidelines, to consider mitigation, lesser sentence, as this was a terribly unsophisticated crime. I know the victim considers that she has been raped. Technically, legally, she has been. In his mind, he didn't think he raped anyone.
But the jury found him guilty.
Well, I believe that. I'm with you there. I'm not contesting the jury's verdict. I'm not contesting the evidence. I'm not contesting what the victim is saying or how she feels about it. Indicating to you from Mr. Summers' position, he never planned or intended to rape her. But as he says, he never planned, intended to kill her. He has been respectful. I do not see him as a danger. He's out 25 years. It's a long time from now. Anything longer would definitely be a life sentence for a 45-year-old man who has never been in jail before, been incarcerated now for 5.5 years. Thank you.
All right, and let me just, for the record, pursuant to the discussion that we had at the bench, you are objecting to anything as to counts 4 through 10, which are the felonies, that exceeds the statutory maximum being 15 years as to counts 4 and 5, and 5 years as to counts 6 through 10. Is that correct?
Yes, that's correct. I do not believe the court can sentence him to more than the maximum for the statutory crime. 5 years on the third-degree felony, 15 years on the second-degree felony. Cumulatively, you could add it all up, and then on the first-degree attempted murder charges, he could get these 32 years, or he could get life on the attempted murder charge. But I do not believe you could send that down to a 15-year or 5-year sentence. I don't know what that rule is. I don't even agree with it. How you could get sentenced for a crime larger than the maximum sentence the statute requires. Mind-boggling.
All right, understand. Ms. Johnson, anything else to state?
Judge, I respectfully disagree with Mr. Marchese in his saying that Trevor Summers is not a violent person. Williams' rule evidence was admitted into this case, and although he has not been tried or found guilty, there was an incident that had occurred, facts that were before you, of an incident that had occurred on February 18th, and there was an injunction in place, and he ignored that injunction, that court order, and he convinced his children to let him sneak into his estranged wife's home and tied her up, put a pillow over her in attempts to kill her and try and suffocate her, and then tied her up and drove her around Hillsborough County and further south for days, and then tried to kill her again when he knew that there was going to be no way out, and he was not going to let anybody else have his wife. She was either going to have to agree to stay with him, or he was going to kill her. And there is you can call it a murder-suicide letter, you can call it whatever you want, but that's what the state would submit to you that letter was. He intended to kill her in that car, and he was going to kill himself. He is a very violent person. He is not someone that should ever be able to be allowed to walk free again. And the state is asking that you punish him and sentence him that is consistent with the crimes he committed, and we're asking for the maximum as to each and every count.
All right, thank you, Ms. Johnson.